Okay. So thank you very much. First of all, at the onset, I'd really like to offer my gratitude and my thank you to the Honorable Vice Chancellor of Mizoram University, KRS Sambasiva Rao sir, for allowing this workshop and really giving us all possible support for organizing this workshop, as intellectual property right is a very important chapter currently in the world scenario, in the global scenario. I hope that the deliberations of today's would really be beneficial to whoever is joined here today, and it will really enlighten us with the topic of intellectual property rights. So to start with, I just like to welcome the Honorable VC Sir, Professor KRS Sambasiva Rao sir. Thank you very much. As I already informed Dr. Rajnikant, Padma Shri Dr. Rajnikant, he will be joining from Banaras after a few moments. At about 12 o'clock, he will be joining us. So, we have with us Mr. Sanjay Bhattacharya, Deputy Controller of Patents and Designs, Patent Office, Kolkata, Ministry of Commerce and Industry, Government of India. We have with us Mr. Debanjan Chakraborty, Senior Examiner of Trademarks, Head of Office and Head of Office and CPIO, Trademark Registry. We have also with us Ms. Pearl Sobti. She is Assistant Vice President, Head for IPR Promotion and Management, Department of Promotion of Industry and Industrial Trade, Internal Trade, Ministry of Commerce and Industry, Government of India. And we have with us Mr. B.K. Bagchi, who is a designated IP attorney and a consultant IP attorney of Indian Chamber of Commerce, Intellectual Property Facilitation Center. Just before I'd like to inform to you that Indian Chamber of Commerce Northeast Initiative has installed an intellectual property facilitation center in the Northeast office, in the Guwahati office, and we are catering to the entire Northeastern states. We have been operational since the last year. Within the pandemic, we had to start. We are working a lot towards that. So this initiative is part of that, and we'd like to inform you that this is the only center in the entire Northeast supported by Ministry of MSME, Government of India. So without further delay, I would now request the Honorable Vice Chancellor of Mizoram University, Professor Rao sir, to kindly deliver his address. Thank you.
Good morning, everyone. It was a great pleasure for me to be here on this day, a combined webinar CI that a very right and pertinent topic being organized by them. And I thank the Mahesh Kumar ji for giving me an opportunity, and also other members, even the chief guest who is going to come, Padma Shri Rajnikant ji, and the CI chief who is also like to join very soon, Debanjan Chakraborty ji and other members, Barwa ji and other members. It was a great opportunity for me to interact with all of you and listen to this particular webinar on intellectual property rights and design, how we are going to have the different property rights, what are them and how it is to be protected, how it is to be propagated to the public. This is very important, particularly for people who are working in science, technology, and business, trademarks, and all those their trademarks, how it is going to be protected. It is one opportunity for them to understand what exactly, if anyone speaks intellectual property rights, people know IPR rules and regulations and patents and trademarks, copyrights, and everyone they talk about that. But actually, what exactly, how to be protected, how it is to be taken into consideration for our utility, it is very important. One should know about that. Intellectual property rights means providing normally anyone who has got invented something, and if he is going to protect his rights on its invention, it is simply say, we can say that right of invention. It is actually right of invention, and it is the people who invents that particular one, they will have a right. So how long they will have the rights, how long it can be commercialized, how it can be protected, how it can be given to others to utilize that one. These are all very important things should be known to people. And it is particularly this AI will be having a great experience with this kind of things. It will be wonderful if they give some information about this one. It will be very good. So normally the intellectual property, that is the knowledge which actually they have achieved and the hard work which they have achieved and the trademarks which they have developed, they should have, the person who has invented this, he should have a right on that. And sometimes it can be say it is a monopoly of that, and it is going to be a right on a particular product which is developed by them, and it cannot be used by others. That's a monopoly, and he only can produce that one, and no one others can produce particular till particular period of that. And it will be what time it is actually it is required and how long it can be a property of the person who invented that. It is very important, should be known to everyone who are involved in this particular activity in science and technology and also in business activities. One should know about this. And it is actually been uh, realizing the importance. The World Intellectual Property Day also is being celebrated on 26th April every year. And there are many issues actually when we are talking about that, particularly the you take the recent example of COVID vaccine, and it is actually been invented by certain companies in India, two companies in India, and outside there are about 5, 6 companies they invented COVID vaccine, and they are not able to supply to the whole world as per the required number. How it is going to be now? It is now government is proposing them to give it to different franchise agencies in the country, and even Bharat Biotech has come forward and they are giving these particular rights to two companies to get more number of more production in the country for COVID vaccine, because our country is really been suffering with vaccination, more than 135 crores of population. It is, if it is not possible, if it is not being produced in a sufficient number, so it has to, if you are going to have the IPR rights and follow the same rules, and after 20 years it is going to be publicized, it is not going to be viable. So it should, within the legal framework, and how they are going to give it to others, and how it is going to be utilized for the human utility, then government can also intervene in this kind of things, and they can request them. And normally this can be liberalized, the IPR rules and IPR rights can be liberalized, and that can be taken up by other helping companies for them. And similarly, this Bharat Biotech, who has invented the vaccine, they are giving to people. It was actually my paper knowledge only I'm talking about that. And I'm not really talking about what is the modalities, how they are following and how they are adopting. I don't have an idea. Usually, if intellectual property rights up to 3, 4 types, like one is patenting. What is patenting? Patenting is actually, it is in particularly in developing a particular new invention, or some developing a new process technology, or developing a new kind of that is product development, and this kind of all these things will come into patenting. So even sometimes people should know that the new ideas also can be patented. For example, if you are planning for some good research, and that can also be patented. Idea also can be patented. Students actually, particularly in chemical studies and pharmaceutical studies and biotechnology studies, actually they will be having a lot of ideas, and those ideas in future, if anyone goes into this idea and they develop some product and it is going to be patented, it will be a big issue for them when they come out with some kind of solution for one particular product. It is actually going to be an issue that it has already been patented by somebody else. This is what actually new ideas and new visionary inventions also can be given as a patent, and a process, and as a process patent or a product patent, or and theoretical patent. This is what actually and as per the if you are Patent Act of India, and these are actually the different kinds of patent. And if you just compare with the patents which we are talking here in India, not really have been aware of this kind of patenting system, that is right of invention, what we are new inventions, what we are having. Not even old number of patents, if you compare, we are not even meeting the requirement of 5% of the patents which are being patented throughout the world. We are very far lesser than the old many countries about patenting things. This is very important that our children and particularly the faculty, teachers, scholars should be motivated for more and more patents actually, and this commercialization of patent is also very important, and they should be provided an guidance and opportunity how to make a patent, how to have a process patent or product patent, and visionary theoretical patent. All this has to be given training for them. More number of patents to be developed by our country, because we listen several times that Indian basmati rice is patented in US, and like that Indian neem tree has been patented elsewhere. And we have this kind of things which are actually the natives of India, and even the serum of the Mongol bison, which is very famous in Andhra Pradesh, actually has been patented by Belgium people. And like this kind of things are actually been patented by elsewhere, the people. This is actually when we are not lagging behind, and we are very far behind the particular things. Actually, these are going to be, there is a danger that the other countries and people who are working in the similar areas, they have a opportunity for patenting them without the knowledge of our country. This is what actually has to be taken care, and particularly it has to be challenged by our government, that those things which are actually natives of our country cannot be patented in other countries. And similarly, the other one actually IPRs covers mostly the copyrights. Copyrights actually, many, if you just see, there are many written works and even Google informations and textbooks which are actually many people, the textbooks which are actually available for sample copies, and they download and they print out, and journals will be normally without the permission from the particular others, they will be copying, and the textbooks are actually been printed and kept in the libraries. In many issues it was happening. This copyright issue of publications, journals, publications, textbook information, and the various various invention achievements which are published in the journals and other communications bulletins actually been copied. So without the permission of the other, some text, some schematic figures, also some kind of achievements which are published in journals, so without the permission of the particular author, one should not take them, and one should not neglect the original author, and they should all take permission, copyright permission from them. This is most important, that it also comes under intellectual property rights. And trademarks, it is one of the another important one, which is also very important. Trademarks, the symbols of the particular product, and also colors of the particular product, and sounds of the particular systems, and design of the particular systems. Actually, these are actually were very specific to particular product. These are actually sometimes, if you just see here, one name which is very popular in one state, actually brand name of a particular institution, and what they do is Vignan is there. Vignan is actually, it is very popular institution in one area, and the other people, what they say, Vignan of Northeast India, Vignan of northern part of India, and they copy like this, and this particular logo, and also the name of the particular organization is also being copied, and this is also very objectionable, and this is also trademarks, and also the names of the particular organizations, and symbols and everything also will be copied. Sometimes there should be very popular issues, actually they will be taken for copying. And the another important one is trade secrets. Actually, it may be the strategic approach of an organization, and the systems of the particular organization, and formulas of the organization. What normally it happens is, when people working in a particular company or in an organization, what they do is they will take out the formulas, they will take out the particular process involved in production of a particular product, and they will go to and tell the other companies who are also involved in the same area. They will be selling these particular formulas, and these things actually, and a competitive situation and environment will be created between the company where he worked, and also he is going to join in the new company. This is how normally a person who is actually working in a company, the other company should not take them at least for another period of 3 years. Actually, this is one of the rules. Normally, many times the rules are being framed like this for preventing this kind of thefting and copying of the technology. These are very important under the IPR policy. So why? So it is very important because uh, the promotion for research and production technologies and organizations of the particular area, and also the individuals who are involved in this, the IPR is very important, that when it is going to be promoted for global use and also for utility of other people, it is why IPR is very important nowadays. And people should understand that this is very important, and they should promote them with a legal justification for taking the particular product or copying the particular product. Legal justification should be there. This is most important, that people should realize about this. This is very important. And uh, uh, even if you just see, there are many cars and houses which are being developed by one particular agency. They are actually being copied. What we do is, normally when we go outside, we see the several houses, several type of vehicles, and when we are uh, designing particular houses, or you are involved in designing one particular car or so and so. So what we do is, we take photographs of those cars which are actually very successful in other companies, and we try to implement or imitate the same thing in our country or system. And for example, when I go outside abroad, normally I saw many things actually which are very unique for that particular country, which are not being implemented in our country. So what we normally do is, we take the photographs and we come back to country, and the people who are involved in this particular area, developing particular area, what we do is, we will give these photographs to them. Normally, I used to do that. Many people who are involved in that, but actually, it is not going to be involved in their own country. I'm bringing the models and telling them, this is one model which I was found very successful model, which has been appreciated by many people when I visited one particular area. So this may be seen by you, how it can be developed in our country and how best it can be utilized for the public. You can just see this. This is what actually we normally tell to the people. But if it is done within the legal framework and also legislations been followed, it will be very good for our country. And also, when we are talking that, and when we are utilizing for the human or public utilization or public health, it will be very good for the people when you are taking something from the other countries. This is most important, that, for example, when a medicine has been developed in a particular place in our area, that one herbal product which is actually been developed for control of COVID. And when he started telling that I use only these products, and when this product has resulted in many things, government used to ask many people who are interviewing him, and many people who are asking him to tell us what is that, what are the products you have used, what components you have added, and how you are going to develop your product like that. How a person who has developed very well, and how you can tell to others that the combinations of the various products is a common sense factor, and no one will tell that. This, but public utility and public emergencies and public panic conditions, this government can intervene in that. And if it is proved that someone has developed something very useful to the public, it can be intervened by the government, and they can even request them to give it to public, and it is very important. And uh, uh, to public utility, and it will be very good for the utility of the people. And even one telephone has been developed by Graham Bell, it is who has obtained patent for the telephone, but this give him the power to prevent, to control, making use this particular phone to the country. It has took a lot of time, and it has taken a lot of time for commercialization, and broadly utilized by many people throughout the country. This is what actually, when it is going to be a natural course of the particular one, it may take several years, like and this is coming into practice, and this will be causing a panic situation to the public, and it is very important that we should we should develop into a commercial utility, and we should develop into a commercial utilization one, and this will be very useful if you can able to keep in your mind, and when your people are developing this particular one, and these agreements which are actually being met with many people, and those things actually has to be taken care by the respective governments, and that should not be taken and misutilized. And if it is not, if it is not going to be utilized for the public, it is the government has to come to rescue for that. And in India, the control general of patents, designs, and trademarks functioning under the Department of Industrial Development Control, which will grant the patents, designs, and trademarks. They will be taking care of all this, and the Minister of Human Resources and Development is in charge of the Copyright Board. And innovation also, it is actually the Innovation and Skill Development Corporation of India is also been taking care of this. And what are the new processes developed and new patents which are developed, and it will be very useful to the public. They will be taking care of them, and they will be industrially applicable parts. They will be guiding them how it can be effectively used, and sometimes even the government also takes care of this kind of things, and they will be helping the particular inventor who has developed this. So this is very important that people, who particularly in the academic institutions and technical institutions and industries, and also those who are involved in commercial business organization, they should be provided with the information of the various various modalities of these trademarks, copyrights, patents, and also the process developments, and all this, how they are going to be useful, and how it is going to be commercialization, and how it is going to be useful for the public, and all these things has to be discussed at length, and people should be, who are participating in this workshop, they should be provided the very good information about this, and the lawful rules and regulations of this intellectual property rights may be provided to the participants who are participating in this one. And it will be definitely very much useful for the new young students particularly, and young talented, innovative people, and who are involved in this one. It will be very good, and it will be very much useful for the young people, and also they should have some kind of thinking to develop some kind of innovations to commercialization. This is what actually this workshop can motivate them and help the young people to develop something. And I'm really happy that I congratulate all the people who are involved in this, and we are very much. I'm also going to listen everything silently, and I may not participate very actively, but I will try to listen these 2 days, and I will definitely participate in this program in into a whole program, and I will also enrich my knowledge in this particular aspect. Thank you very much for giving me an opportunity to interact and say a few words on this occasion.
Thank you very much, sir. Thank you for the vast description of the things, sir. Thank you so much for sharing your views, sir. We are sure that Indian Chamber of Commerce and Mizoram University in the future, we will be working very hard for this to enliven the intellectual property regime in Mizoram. Now, I would like to invite Mr. Sanjay Bhattacharya, Deputy Controller of Patents and Design, Patent Office, Kolkata, Ministry of Commerce and Industry, Government of India, to kindly deliver his address.
Thank you very much, Mr. Mojumdar, for giving me the opportunity. And I think we are already behind the schedule, so I should like to start immediately. So, shall I start? Sure. Okay, thank you.
Yes, sir, sure.
Yes. Actually, I am representing Patent Office, Kolkata, and which is under Ministry of Commerce and Industry, and it is under Department for Promotion of Industry and Internal Trade. And now we are going to discuss about patent protection. Actually, the word IP intellectual property and creativity are synonymous. Now we are having a population in India of 138 crores, and our Indian society is very ancient society, and we are very much innovative, and we are having lot of historical monuments in India, in different parts of the India, which was built long back, thousands of years ago. And the technology which was used, it was so sophisticated that with the time it is still there. And if we go to South India, we can visit some temples where musical pillars are there. And it is very much surprising for people of Western world that how this kind of thing can be constructed, or rather it was done on so many thousands years of years ago. So that is the beauty of our Indian culture and Indian civilization. Now, what is the need of the hour? The need of the hour is that we should try to create more and more IP. And why it is required? Because now, if we go about copyright, then creation of good music or song, it will give a very it will just reveal your stress, and it becomes music is having a healing power also. But actually now Western world, and we are in a now today, everything is we are competing against each other. Now out of that angle also, IP is important, and instead of competing, we should support each other, because today's society we are having a lot of problems. We are having a lot of difficulty, especially because of pandemic. There are some measures which needs to be taken in order to combat that pandemic situation. And for that, the technology can come forward, and it may be of great help. So that is why this IP protection can play a crucial role, not only under this pandemic situation, also to strengthen our economy. And in order to get the better output in this better creation of IP, lot of steps have been already adopted by Government of India. And now we are it is a tea, it is a very common product. And now we are in this program, it has been organized by ICC and along with Mizoram University. And it is located in Northeast. And the largest northeastern state is Assam, which is very famous for tea. And I am giving presentation from Kolkata office, which is located in West Bengal. So now the first GI, which was given by GI Registry of India, that is on Darjeeling tea. So tea now that tea, it is coming, it is having GI protection, and now there are several types of machineries are used to just making or processing of tea leaves, and then packaging, and all are can be covered under patent protection. Now this packaging part, and say the kettle or cup and saucers which we use to serving tea, that can be of different types of features and surface pattern, shape and configuration, and it can be protected under design registry. And there may be some particular brand of which tea we are is very much famous, and that can be protected under a trademark. Now there may be the literature regarding how to make the proper tea, or sometimes it is written in the packet itself, so that can be protected under copyright protection. So just this is the in brief, all different IPs are covered in simple, that in a cup of tea. So that is very interesting, obviously. Now, I'm from Patent Office. Now, Patent Office is under the control of Controller General of Patent Design and Trademark Registry, and it is under the Ministry of Commerce and Industry, and 6 different IPs are under the control of our Controller General. That is GI, and GI office is located in Chennai, and copyright it is in Delhi, Dwarka, Delhi. Design registry it is in Kolkata, and trademark it is having 5 offices in 4 metros and also in Ahmedabad. And patent office it is in 4 metros: Kolkata, Mumbai, Delhi, and Chennai. Now, this slide, basically, it is a gist kind of thing. The period of protection for different IPs. That is a patent for 20 years. Design, it is initially for 10 years. And subsequent further 5 years can be, if it is renewed, then it can be 10 plus 5, and altogether 15 years. And for getting that next 5 years, one has to submit a request in a design registry within 10 years for 5 years extension, and then it will be extended for next 5 years. And for trademark, it is initially 10 years, and it continues subsequently if it is extended. And same is for GI. And copyright is for, say, stories and paintings and songs. For it is lifetime of creator and plus 60 years. For integrated circuit design, it is 10 years. And for plant variety, it is for crops, it is 15 years, and for trees and vines, it is 18 years. Now, this is the location of our different IP offices. Now, patent office, it is located in 4 metros. It is Kolkata, Delhi, Chennai, and Mumbai. And trademark is in head office in Mumbai, and other offices in Delhi, Kolkata, Chennai, and Ahmedabad. And GI registry is in Chennai. Copyright and integrated circuit design is in Delhi. And design office is located in Kolkata. And our training center, our Rajiv Gandhi National Institute of Intellectual Property Management is in Nagpur. So our officers and general people who are interested to get trained in IP, that is conducted from our Nagpur office. Now, Patent Facilitation Center. Now, India is a vast country, and we are having a huge population. And now there are 2 issues. Now, people should have an innovative idea first, and then how to protect it. And then the role of patent is coming. Now, one may have a very good idea, but maybe he is having innovative brain. He is having such a brain that he can create so many new things, and he can have a solution of day-to-day lot of problems which we are facing day-to-day life. He can have a solution. Now, okay, he is having the solution. Then what to do? Now, how to get his idea to be protected? For that, he should have that knowledge. That is, first thing, he should have the knowledge that it should be protected, or it can be protected, and how it can be protected, and what is the benefit he is going to get out of his protection. And for these issues, the role of a facilitation center is very crucial. People may be having innovative idea, but he is not aware that it can be protected. And out of his innovation, he can get, if it is patentable or if it is novel and innovative, he can get patent, and out of his patent right, he can make money. That awareness is not there, and for that purpose, facilitation centers are very much essential. Now, panel of facilitators has been earmarked, and their list is available in our IP India website. where Controller General of Patents and Design has nominated the list of facilitators who are providing that assistance to the startups free of cost in order to get their IP rights registered from patent, design, or trademark offices. And what are the assistance they are providing? Those facilitators, they provide assistance in filing and from filing to till the disposal of that IP applications related to patent, trademark, and design under relevant acts, including appearing on behalf of startups at hearings. Now, what about hearing and what that term hearing is coming? Now, once the patent application is patent, trademark, or design applications are filed before respective offices, it is examined, and after that, examination report is issued to the applicant or applicant's representative or agent. In case of startup, the report will be forwarded to his facilitator. If he is opting that, if he is opted for a particular facilitator and he has filed through him, then that examination report will be forwarded to that facilitator. And now that facilitator will submit the reply, and after submission of reply, again it will be examined, and if it is found it is not in order, then before refusing that application, a hearing will be offered. So in that hearing also, the startup, on behalf of that startup company, the facilitator will attend the hearing. And after that, after hearing, he will give the written submission for final decision of the appropriate authority. And after that, and all these activity which is being performed by the facilitator, it is free of cost. He is not going to charge a single paise for that from that startup company. And all the remuneration for facilitator, that is paid by Government of India. And under this scheme, the central government shall bear the entire fees of the facilitators for any number of patents, trademarks, and designs that a startup may file, and the startup shall bear the cost of only the statutory fees. That means the filing fee, request filing fee, etc., will be paid by the startup company. And the fee structure is also less for startup and same under the category of individual inventor. Now, what is the objective of that scheme? The scheme of facilitating startups intellectual property protection aims to promote awareness and adoption of IPR among startups. Scheme is inclined to nurture and maintain innovative and emerging technologies among startups and assist them in protecting and commercializing it by providing them access to high quality IP services and resources. Actually, now if we just search that total share of startups, total turnover of different industrial turnover, if we take the statistics of India, then a sizable portion of it is coming from startups. So their role is very crucial, and today's startup, tomorrow they may be a giant company. So it is their formative years, and at this juncture they need to be nurtured, and then only they can grow up. And once they grow up, they will be bringing a lot of they are going to generate a lot of employment, and they may expand, and they can just flourish, and in such a way that they can set up their business, or they can expand their business to other companies, other parts of the world, and they can generate huge revenue, and which will boost our economy. So that's why that policy of nurturing startup has been taken up by the Government of India. Actually, now this slide is a bit old. Now, for startup, what is the definition of startup? Startup has been defined to mean an entity incorporated or registered in India with an annual turnover not exceeding, in place of 25 crores, it is 100 crores in any preceding financial year, and working towards innovation, development of new products or services driven by technology or intellectual property. And now, why this support has been given to them? Now, startups, they are having limited resources and manpower, and they can sustain in this highly competitive world only through continuous growth and development-oriented innovations. And for this reason, it is equally crucial that they protect their IPR. Otherwise, they cannot, suppose they have developed some new technology, but it is not protected, then what may happen? It may happen that some competitors who are reputed company, they can just utilize his IPR because they are having better infrastructure and they are having better market share and they are having better presence. They just simply copy that technology if it is not protected. So that's why the protection of IPR is very much essential for this. And these are some benefit which is given to startup in order to for encouragement and for their survival also. And another most important issue is regarding this one aspect that is related to our office, that is expedited examination process. Now, normally what happens once the application is filed, and after that, within 48 months from date of filing of that application, request for examination can be filed, and request for examination can be filed along with the filing of application or subsequently within 48 months. Now, in case of startup and also those companies who have opted India as a search or preliminary examination authority, they are eligible for expedited examination process. Now, what is that? Now, for expedited examination, they have, if they choose, the startup company can choose, they have pay the appropriate fees for that, and then immediately within a month, his application will be examined. And that is how that once the examination report is issued, within 6 months time, he can file his reply. And he is free to give his reply any time within 6 months or before. So immediately, suppose within a month or say 15 days, if it is reply is received by this office, and then it will go for re-examination. And during the course of examination, if it is found that everything is in order, then immediately after receiving his reply, say within very short time, we can grant his application. So there is one example has been given that say within 6 months we have granted that patent application. And these are some benefits that 90% of refund for application if it is withdrawn, that after filing if it is withdrawn before examination, then 90% fees are withdrawn. And within 21 days, if the startup company is willing to file in abroad, then that licensing is process is cleared within 23 weeks. And there is some tax exemption scheme for startups. And regarding the facilitator part, it is already discussed. And these are the fee structure for startup and legal entities. Now, one can just find out from this slide that for filing fee, if it is filed online, then it is just 1,600 for startups. And whereas for legal entities, it is 5 times. So it is 8,000. So that way, startups are getting fee benefit also. And for request for examination, that is Form 18, it is 4,000 for startup or individual, and for legal entity it is 5 times, it is 20,000. So that way it is for expedited examination, they need to pay only 8,000, yes, 8,000 rupees, whereas for suppose a company who has opted India as a search authority, if they are ready to go for that expedited process, then they have to pay 60,000. So that is the fee-related benefit we are providing to the startup, and all as a whole, there is a very good scheme has been provided for protection of intellectual property of startup in the field of design, trademark, as well as patent. And it is now the startup has to come forward to avail that benefit and get their intellectual property properly protected from patent design as well as trademark office. Now, there are some practical scenario what the startup companies are facing. That in their initial stage, they are not getting in proper funding because they are new in the business, and suppose one is investing. Before investing, everyone is looking after the return over investment and security of his invested fund. Now, for investing in a startup, it is a high risk nature. So that is the disadvantage all the startup companies are facing. And now various exemptions are given to them, and as well as the income tax exemption, and as well as that their IP protection can be done in a very fast. So these are the advantage given to them in order to just overcome the difficulty of during their formative years. And that tax exemption part is initially for that is for 3 years. Now, who can be the facilitator? Now, any patent agent or trademark agent and any advocate as defined under the Advocates Act 1961 is entitled to practice law as per the rules of laid down by Indian Bar Council and government departments like TIPAC, NRDC. They can also get them registered as a facilitator. And these are the responsibility of the facilitator. Now, what they are doing actually, they are providing information on protecting and promoting IPR of startups and assistance in filing and disposal of the IP applications related to patent, trademark, and design under the relevant acts and the national IP offices under control of CGPDTM, and drafting of complete and professional specification for inventions of startup, preparing and filing responses to examination reports and other queries, and notices and letters by IP office, appearing on behalf of startup at the hearing as may be scheduled by the IP office, contesting opposition, if any, by other parties, that means pre-grant or post-pre-grant in case of patent, and ensuring final disposal of the IPR application. And these are the fees which is given to the facilitator by Government of India. In case of filing of patent application, it is filing stage, it is 10,000, and for trademark it is 5,000, and for design it is 2,000. And at the time of disposal of that particular application, it is again 10,000 for patent, 2,000 for trademark, and 2,000 for design. And if it is disposed after hearing, then for patent it is 15,000, and for trademark it is 5, and for design it is 4,000. And now there is some figure. The total number of applications filed during 2016 to 2019. by startups. That is, total figure is around 12,000. And there are some names which are prominent among filing patent applications, startup companies. And this is the filing data. You see, initially when it began in 2016, it is just around 500, and then it crossed 2,000 marks in 2017, and it crossed 4,000 mark in 2018. And this is the data of expedited examination filing. It is around 100 in 2016, and then more than 200 in 2017, and it crossed 500 mark in 2018. Now these are the grant data. It is 45 in 2017, and 227 in 18, and 309 in 2019. And overall, total 581 applications granted till August 2019. And total filing was 1350, and total grant is 581. So that's all. Now, if you have any question, you can ask.
Thank you, sir.
Yes.
Thank you, Sanjay Bhattacharya, sir. You have always provided very positive inputs to us in all our webinars, and I'm sure you'll be doing so. Thank you so much, sir.
Okay.
Now, I would like to call on Mr. Debanjan Chakraborty, Senior Examiner of Trademarks, Head of Office and CPIO Trademarks Registry, Kolkata, to kindly deliver his presentation. Thank you, sir.
Yeah, good morning. Can you hear me, Pranam?
Hello, yes, sir.
Yeah. I will be sharing one.
So you will be sharing a PPT?
Yes.
Right.
Yeah. Is my PPT viewable?
Yes, sir.
You can make it full screen, sir.
So please go to the slideshow. Yes, then click from big. Yes.
Yeah. Can you see the thing? Yeah. Good morning, everyone. Today I will be briefly discussing the registration aspects of the trademarks. Hello. So, trademark in this, I'll be discussing trademark. Trademark is basically needed for each and every business house or any individual who is planning to do any business or any planning to do any kind of provide service or manufacture anything in order to distinguish himself as an entity and for selling and providing service in a brand name. How come? So trademark may consist of a word. It may be a signature device. It can be a brand name. Any combination thereof. And this is a brief examples of the trademarks what any individual or a service provider can choose from. Basically, if you have a brand, you can encash it upon and later on capitalize on it. These are the shape of a bottle or a name, symbol, the color. These are the subject marks of a trademark. Whenever a person is actually trying making a trademark or choosing a trademark for his firm, he should not solely concentrate on only the name. It can be any device, it can be any symbol, even the color can also be part of a trademark that can be registered. How does this concept of trademark came into place? Is recognized only after Industrial Revolution. Product manufactured or services rendered by companies are marketed or provided respectively using its own trademark. Once you have your trademark, you try to advertise the trademarks. That becomes popular and acquires goodwill. In order to prevent piracy and duplication, registration of a trademark is very much required. To protect the goodwill of a trademark, that is also very vital, so that any person who is having ill motive should not be encashing upon it. And after which the laws were enacted in India. The first Trademark Act 1999 came into force in 15 September 2003. The old Trade and Merchandise Act 1958 was repealed at the same time. Similarly, Trademark Rules 2017 came into place, replacing 2002 rules. First schedule of Trademark 2017 provides a comprehensive classification of different types of trademark associated with different goods, services, and that can be registered in India. So now I will briefly explain what the trademark is. Mainly anything that you can represent in a graphical two-dimensional page, that is part and parcel of the registration. You can get it registered. These are the important provision of trademark. Services were also protected under trademark laws. Goods and services were extended to 45 international categories. Registration of a trademark were extended up to 10 years. Special protection were also given to well-known trademark names. Protection across goods, service if brand is reputed. Trademark that can be registered. Standard trademark are those that are affixed to the identified goods or service. Series marks are marks represented in the form of series, different font or colors. Certification trademark certifies the nature of origin of goods or service to which it has been applied by. Collective trademark is the registered name of a group, association, or other organization for use of member of groups in commercial activities to indicate the membership of the group. The legal requirement of a trademark under registrations are: mark should be capable of being represented graphically, that is in a paper. It should be capable of distinguishing the goods or services of one undertaking from those of others. It should be used or proposed to be used mark in relation to goods or service for the purpose of indicating or as to indicate the connection in course of trade between goods or services. And some persons have the right to use the mark with or without identity of that person. Who can make the application? Any person who claims to be proprietor of a trademark used or proposed to be used by him for goods as well as services. In case of a company about to be formed, anyone may apply for a trademark registration in his name for subsequent assignment of the registration of a company's favor. What are the benefits if you get your trademark registration? Though registration of a trademark is not mandatory in India. The registration of a trademark confers upon the owner the exclusive right to use the registered trademark and indicate as to by using symbol R in relation to the goods or service in respect of which the mark is registered and seek relief of infringement in appropriate courts of law. The term of registration is 10 years, which may be renewed for further period of 10 years on payment of prescribed renewal fees. It is you can continue your renewal. There is no time limit for trademark. However, non-usage of a trademark for a continuous period of 5 years is a valid ground for cancellation of a registration of such trademark at the behest of any aggrieved party. This is a brief structure of CGP Ministry of Commerce and the Department of Industrial Policy and Promotion. This is we are in Calcutta. We are having jurisdiction of Arunachal full northeast. And nowadays, you don't need to visit our office. You can file it online mostly. This is a brief procedure of trademark. Whenever new application comes, we examine it. After examine, if it is novel mark, then it will proceed for publication. If some objections are there, then we'll call for show cause hearing. Then after show cause hearing, if the mark is passed, it will be published. And after which, if there is an opposition, then opposition proceedings will continue. After opposition proceedings, your mark will be getting registered. It's the same thing. Now, most of our applications are filed online. This is we have the website iprindia.gov.in. All forms and everything is available online. You can just download the forms, fill it online, and everything will be automatically taken. We'll be adjudicating your applications online, and even we are facilitating virtual hearing. So we don't actually, if anyone wants to connect with on the show cause hearing, he can be there in his office, and on a virtual mode we can he can present his case. This is briefly our website looks like. If whenever a person or an enterprise plans to give a name, it is thoroughly advisable to him to go for a public search, see that his name is not already existing in our records. Just this is the trademark icon. You can just search, do the public search, and this is first icon is comprehensive e-filing. Second is public search. This is a public search. You can search any name, whatever it is. Starts with, you can give ABCD. Then if you put in the class and do the search, all the marks starting with ABC will be shown in our website only. So there is no need of creating a confusion in your mind. Whatever in our record, it will be just reflected to you as soon as you search it in our website. After that, you can get yourself file an application and get yourself registered. This is all forms and are already there in the website. Forms and fees structure is there. We are actually giving 10% discount is presently there for online filing. So any individual who is actually wanting to file, he can go for online and he can save up to 10%. And that too, if through startup is there, he can be getting various rebates from MSME or various agencies are there. He has to get himself registered. This is the form PMA. This is how it looks like. This simple form, just fill in your application details. the trademark the logo. You just need to paste it there and scan it. It will be uploaded there. For if you make any kind of mistakes in your application, if you find it later on, just need file TMM to correct it. This is a renewal TMR. This is for renewal. Once you get registration, it will be valid for 10 years. After which you need to file renewal charge. This is the form TMR for doing so. It's very simple. After in 2017 rules, the forms have been made very simple. Just you need to fill in your name, address, and basic details you have to put in, and after which you can get yourself registered. This is TMC for copyright NOC. If anyone wants his any logo or something to be copyrighted, he can go for TMC. And if any lawyer or attorney he wants to get himself registered with our department, he can apply for TMG. In this TMG, he can get himself registered and he can file for the applicants. This is briefly the journal publication, how it looks like in our website. All the trademarks which are published and which are prior to registration are published in the official gazette, and all the details are there in the website. So you can, anyone can just look at the website and check whatever marks there are published and that are there. This is how briefly previously our certificate looks like. What are the acts infringement of a trademark? And now I briefly explain you what are the benefits of getting your trademark registered and what are the how infringement takes place. Acts constitutes infringement, affix registered trademark or to goods or service, offer sales, stocks or supplies goods and service under registered trademark, import or export under registered trademark, use of registered trademark on business paper or advertisement. If someone uses or copies any registered trademark, uses in goods, offers sales stocks, or import under registered trademark, he will be subject to infringement. Suppose if you have a registered trademark and someone else copies your mark, then a suit for infringement can be filed. A suit can be filed in district court having jurisdiction. A suit can be filed in addition to district judge in High Court of Delhi, Mumbai, Calcutta, and Chennai, whichever has the original jurisdiction. What are the relief you can get? Mandatory injunction restraining defendant from using the trademark, damages and cost, surrender of infringed goods, surrender of label, bills, coding. Even criminal penalty is also there. The penalty for selling or providing service using false trademark is minimum of 6 months and maximum of 3 years, and with fine not less than 50,000, but which may extend to 2 lakhs. Use of TM symbols. TM symbol, generally who has applied for trademark application, he can use TM, but it is usually practiced before registration. Once you get your registration, you can use the symbol R when the mark is registered and certificate of registration is issued by the registrar of the trademarks. The work from home, this is we are actually doing. Thank you. Any questions regarding trademark? Then I will be briefly going to GI.
So thank you, sir. So we will have an interactive session after all the speakers' deliberations. So kindly be there for queries because there are queries coming in. So we'll put those queries during the question answer session. Fine, sir.
Okay. So I'll start with GI.
Yeah.
Okay. So I briefly
Fine.
Okay. So I'll briefly introduce what the geographical indication is all about. Geographical indication, there was no specific law as such. In 15th September 2003, the Act came in, and we'll briefly just explain what the geographical indication is all about. It is an indication or appellation of origin. It is used to identify agricultural, natural, manufactured goods originating from specified geographical area. It originates from definite territory. It should have a special quality or a characteristics or reputation based upon the climate or production characteristics unique to geographical location. In case of manufactured goods, one of the activities of either production of processing or preparation of goods takes place in the said area. Almost all kinds of goods are covered. Manufactured goods include handicrafts and handlooms. The register of geographical indication is divided into two parts. Part A consists of relating to registered geographical indication, and Part B consists of particular of registered authorized user. The registration process is similar to both for registration of geographical indication as an authorized user. GI registration provides a registered proprietor and authorized user the exclusive right to protect the registered GI on specified goods. Monopolization of market enables the producers to control price, that is, can charge premium price, thereby enhancing profit. Studies reveal that 80% consumers are prepared to pay 20 to 30% higher price for goods they believe are having better qualities over goods. Widespread imitation. What was the scenario for pre-tip scenario? I'll come into who can make the GI application. Any association of person or producers or any organization or authority established by or under the law can apply for time being in force representing the interest of the producers of the concerned goods in writing or online. Application should be content statement as to how the geographical indication serves to designate the goods as originating from the concerned territory or the country or region or locality in the country. The registration of a geographical indication shall be for a period of 10 years, but it may be renewed from time to time in accordance with the provisions of law. The process of registration must be made in appropriate form containing the nature, quality, reputation, or other characteristics of which are due exclusively or essentially to the geographical environment, manufacturing process, natural and human factors, map of the territory of production, appearance of geographical indication, appearance of geographical indications, figurative or words, list of producers along with prescribed fees. The examiner will make a preliminary scrutiny for deficiencies. In case of deficiencies, the applicant has to remedy it within a period of 1 month from the date of communication. The registrar may accept, partially accept, or refuse the application. In case of refusal, the registrar will give written grounds for non-acceptance. The applicant must, within 2 months, file reply. In case of refusal, the applicant can make an appeal within 1 month of such decision. The registrar shall, within 3 months of the acceptance, may advertise the applications in GI journal. If there is no opposition, the registrar will grant a certificate of registration to the applicant or authorized user. How is GI and trademark different? GI and trademark supposed to be complementary, not competitive. However, there are fundamental difference between the trademark and GI. Trademark indicates that the products are affiliated with the manufacturer. GI denotes the source of origin, where product quality or specialty that consumer prefer is governed by specific physical or biological environment. TMA implies certain amount of human creativity and is usable only by one agency or entity. There is no invention or discovery involved, and GI may depend on traditional knowledge for that product development or on the talent of the craftsman. GI can be used by all those who produce that product in that given area. What is GI and rural economy? GIs are mostly from villages or small towns. Higher income for the producers from these regions have the potential to transform the rural economy for the better. Assured market attracts investments. GI and industry, many registered and potential GIs of India are in micro and SME sector. GI protection enables them to develop their market and increase return. GI and traditional knowledge, many GI products enshrine traditional knowledge. Cases of metal mirror from Kerala, cases of Madhubani paintings from Bihar. GI and consumer, GI protection is consumer, pro-consumer also. A GI product is a quality assurance for the consumer also. It is guarantee for the genuineness of the product. GI and quality assurance, GI products have to ensure of their consistency of their quality and unique characteristics, needs regular monitoring and inspection. Proprietors and authorized users should establish self-regulating mechanism. What is to be done in GI? Especially for the Northeast, there are various huge potential of GIs that can be applied for. Identify all potential GIs in the country, prepare detailed documentation on each of them, organize the producers, apply to register the potential one, take measures for protecting the quality. For Asia. Thank you. If any question or anything is there, please.
Well, thank you, sir. So we will have a question answer session. So we are having queries from the delegates. So the delegates, I request you to kindly let us complete the deliberations, and after that we will go for the question answer session. Fine?
So we have already joined. Good morning. We have already joined.
Yes, sir. Sir, good morning, sir. Good afternoon, sir. Honorable Vice Chancellor, sir, I would like to inform that we have been joined by Dr. Rajnikant, who is a Padma Shri, and he's joining us from Banaras. He has been working in the field of intellectual property rights for the last 15 to 20 years. He has an extensive experience with us. So I'm very grateful to you, sir, for being here today. So now I request you to kindly, sir, deliver your address to the gathering. Thank you.
Okay, good morning, all of you, and especially the respected Vice Chancellor of the Mizoram University, the people from the IP office of the Kolkata, and the important to the Indian Chamber, who has invited me for this initiative to talk on the GI issues. Geographical indication is a complete community property, and this is very close to the people. GI is only a thing who can give the guarantee that this is the local. If we are talking about the Mizo chili, it means no can produce the Mizo chili in any part of India, even not in a part of world also. So this is the important. And when we are talking about the initiatives, so the initiative is taken by the industry also, by the universities also, and the GI registry is supporting in a significant manner for the Northeast product, including the Assam. So why we are talking about the GI? I will not talk about any theoretical cheese. But we are talking about the Sone ki chidiya, golden bird. When in the early time, the people say that India is the Sone ki chidiya, India is a golden bird. So there is no golden bird, but it is the flying. जो सोने की चिड़िया है, this is the handloom, handicraft, agriculture, horticulture, products, millets, and the very exclusive food product, which has looted by the Mughals and also looted by the Britishers from this geographical region, and they sail across the world. But we are grateful to the excellent artisans, the weavers, the farmers, who has protect their intellectual property. Only the geographical indication is a community property within the IPR. The patent, trademark, copyright, trade secret, everything is a individual property. But the geographical indication is a community property. When the Honorable Prime Minister of India is saying, Atmanirbhar Bharat, global, local to global. So what is the local? So the GI is a legal local product. So that is very much important. And huge potential whole Northeast region. Yesterday, the Honorable Prime Minister of India was in Varanasi. And I am proud to say that all the movement given to the Honorable Prime Minister of India and the Japan ambassador by the Chief of Uttar Pradesh. So all was the GI product. So this is the branding. So I know you well aware about the GI, but the most important thing is the post-GI initiative also. And I'm sorry to say that due to the very long process, how only 325 Indian GIs are registered from 2003. The first GI is the Darjeeling tea. But what is the fate? If the people will not increase their income, if the producer will not get the good price, and if there is a lot of the infringement cases, so how the producers will be benefited? Because they are the real stakeholders. So, and in the Northeast, huge potential. In the East also, in the Bengal, in the Odisha, and every part of the many tribal products are there. One is very important. When I go through the Mizoram products, the 6 products has registered from the Mizoram. And only one product is the agriculture product. The rest are the textile product. But unfortunately, the GI authorized user, who will use the GI tag? So in the GI authorized user can use the tag. Even the applicant who is because I am going through the Mizoram document. The government department is applicant. In the fact, the most important thing is the applicant will be producer association, related societies, related cooperatives, and because they are the owner. So that is important thing. But there is no GI authorized user, only one GI authorized user is there. In every product, in all 6 products, only Trifed is the GI authorized user. And I am surprised to know that the Mizo chili has registered in 2015. From 2015, only one authorized user. From 2019, 5 products. This is when the government will be applicant. They are not taking the post initiative. That is very much important. This is also the of the chambers. They come forward and sensitize the government department. This is the responsibility of the universities. They come forward and can involve the local NGOs. When you will involve the NGOs, the local NGO, non-government organization, local cooperative society, they will take the process of the GI authorized user. And anyone who is related to the product can be a GI authorized user. Anyone, either the weaver or the artisan or the related farmers or the traders or the exporters can be authorized user, because only authorized user will be the legally a person or a society who can apply it. And this is a very simple process. This is very simple process. Only 10 rupees is the fees of the GI authorized user registration. Now the GI registry has given a very simple format, one-page format. And through the one-page format, any person can file and they can take the NOC from the applicant organization. Why this is necessary to take the NOC? Because suppose that I am in Varanasi, if I can file a GI authorized user for the Mizo chili or the Hamran, so Hamram, so the registered proprietor, who is the applicant, can ask me why you are interested to take the GI authorized usership of the Mizo trader, or you are a businessman, or you are an exporter. So if I am a genuine person, then he will give the NOC, either not. So the person who is directly associated with the product from producer to the exporter can be a GI authorized user. And then he will, because the GI registry will send the separate GI registration certificate, GI authorized user certificate with a separate number. And we are also working with the government of India, with the various departments at the policy level. So the government is going to decide the QR codes. Any people can verify through the QR codes that where the product is coming, who is the GI authorized user, what is the things. Not. If anybody can violate, any stakeholders can file a suit in the civil court. So this is the loss of the community. This is not the loss of the individual. And he will penalize. So kindly take the initiative. And this is very much responsibilities of the universities, the academic institutions, the trade associations. Government will work after the GI, like the training, capacity building, brand building, packaging, marketing support. The government can sell in the various exhibitions. Only exclusive GI exhibition in Delhi, Mizoram government, either the any Northeast government, you have the separate ministry also. So only GI authorized user, like the TriFed is taking very important initiative for the marketing. So any GI product can come on the counter of on the stall of the TriFed. They have 100 showroom across the country. So, but who can join the TriFed? The GI authorized user only. So no registered proprietor will come in on the counter. Proprietor could not use the GI logo. You can see the national GI logo just behind me. This is the national GI logo. But only the authorized user can use, or the person can use this one. So this GI logo, and then you can take the initiative. So this is the very much important. You can use the GI logo, the government can use the GI logo, the universities can use the logo, national GI logo, for the publicity, for the branding, not for the commercial purpose. There is no provision to use the GI logo, national GI logo, but the GI authorized user will use the national GI logo for commercial purpose, the product GI logo also, because in each GI there is a separate logo registered at the time of the GI registration. So this is also important. So kindly take the initiative, and I am for the cause of nation. So I am available every time and I am not a consultant. So I will not charge the fee. I will not charge the fee since last 30 years. in the development sector. Basically, I was a scientist in Banaras University. In 1993, I joined the social development sector for the women economic empowerment, the self-help, non-subsidies. And from 2006, we have started the GI issue for the protection of the community right. And up to this period, 62 GI has facilitated by myself across the 8 states. And maximum are in the process of the granting. In the Varanasi only, 17 GIs are there. So there is huge potential in the Mizoram, the Manipur, the Nagaland, Arunachal, Sikkim, Assam, all 7 sisters state, and Assam, Tripura also. So a huge potential. Please come forward and take the initiative in a significant manner. Take the initiative in a significant manner. And I am always available for the cause of community. In any time, any person can call us. And I am again repeating, I am not a consultant. We can work together in a partnership mode. We are working with a number of universities like the Jammu Kashmir, the Sere Kashmir universities. We have recently filed the 5 products from the Jammu region, from the Ladakh, Kashmir, Madhya Pradesh, the various states, and few are working there. So I am available and I am thankful, and any person can contact me anytime, and the contact me, the academic institution can contact me, and I am available for the cause of the GI community and fulfill the dream of the Honorable Prime Minister of India, who says the tribal people have much more right, because we have not actually worked with the tribal people. So in the Vandhan Yojana, we can also link with the Vandhan Yojana to the GI, and many tribal products, even in each tribe has their own product, own food, own dress, own culture, own agriculture product. So kindly take the initiative, and we all work together for the nation. And we believe that again this nation will recognize across the globe as golden.
So thank you, Dr. Rajnikant. So thank you, Dr. Rajnikant, sir. Thank you for the exuberant delivery from your side. Please be there, sir. We will have a question-answer session after the delivery. So request you to be there. There will be queries from the delegates present here.
Okay.
Thank you again, sir. So now I would like to invite Ms. Pearl Sopti, Assistant Vice President, Cell for IPR Promotion and Management, CIPAM, Department of Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India, to kindly deliver her address to the gathering. Ms. Pearl Sopti.
Hello.
Yes,
Am I audible?
we can hear you. Yes, you are
so
audible.
I would like to share a presentation. I'll share that.
Fine.
Good afternoon everyone. It's an honor to share the podium with such learned, knowledgeable people. And I'll not take much of your time, and I'll just take you through what are the government initiatives on the IPR fronts, just focusing on startups and MSMEs, considering they drive the knowledge economy. So India is currently already in the top 50 innovative economies. We want to go higher in the scale, and in going higher in those scales, we would require contribution from SMEs and startups, because those are one of the key pillars of any knowledge-based economies. And I'm more than happy to share this, that even the Western countries, we have collaboration with many of them, are impressed with initiatives Government of India has taken up in developing their MSMEs and startups. So coming to the slides, so for Government of India, Startup India is one of the key initiatives which they have taken to boost the startup economy. So currently we have around 50,000 startups which indirectly have created 5.5 lakhs jobs in India. And it is a good to know thing that each state and UT has at least one startup, and there are states which have very major focus on startups, starting from Maharashtra, Karnataka, Delhi, UP, Gujarat. And government has been on regular basis initiating different schemes to promote them further, like Funds of Funds scheme, which has an overlay of 10,000 crore, and a Startup India Seeds Fund scheme, which has an outlay of 945 crores. So this is what is on a broader horizon government is doing. Now we'll take you through what are the IPR initiatives government has taken to boost the knowledge economy. So some of the points have been already being covered by the CG office, learned examiners and registrars. So I'll just take you briefly through them. So one was that reduction of fee for small entities as well as startups, which has been brought down equal to the individuals in case of patent filing and prosecution. They have been provided and provision wherein you can file for an expedited examination. They are eligible for expedited examination, which makes and faster process to get a patent application or a trademark application taken through on a faster pace. Similarly, as told earlier also, we had extended the scheme of Startup Intellectual Property Protection Scheme, wherein the government has enrolled patent and trademark facilitators, and the fees of these facilitators are being paid by the government. And it is just to boost both filing as well as prosecution of the various patents and trademarks filed by the startups or the MSMEs. Similarly, considering we had already done something for startups and MSMEs in patent and trademark in 2021, another design amendment rule was brought in wherein the startup and small entities fees was further reduced in line with the individual inventors. So these were one of the legislative changes which government had done to boost the economy. And there were initiatives on the awareness front, wherein Ministry of MSME has a scheme on building IPR awareness, and CPAM has been in very good cordial relation with MSME and has been organizing various MSME-driven and startup-driven programs in collaboration with them. And in last year, we had conducted around 200 such programs. Similarly, MITI also has a scheme wherein they promote awareness as well as provide financial support for international patent protections for startups and MSMEs in the area of electronics and information technology. So coming to all these initiatives have led to an increased number of domestic patent filings from, say, 16% increase from 1920 to 2021, and a domestic patent grant has been increased from 40 to 47%. Similarly, an increase in filing was observed for in context of patents as well as trademark filing. Further, there have been a significant number of filings on patent and trademarks by startups. Say since till April 30, 2020, we had filing of 5649 and around 15,000 patent filings and trademark filings from patents and trademarks. So these areas wherein government is keen on and has been regularly initiatives, we would look forward to have similar contribution to the economy from the startups and MSMEs in this regard. Thank you so much. I wanted to keep it brief so that people are.
So thank you, madam. Is it done? Thank you. So thank you, Madam Pearl Sopti, for being there and for your presentation. Kindly be there. There will be a question answer session, so there might be queries from the delegates. I request you to kindly be there during the entire session. I would now request Mr. P.K. Bakshi. He is the designated IP attorney of Indian Chamber of Commerce Intellectual Property Facilitation Center, Guwahati. He has been in the field of IP since the last 15 years. So currently, whenever we do any registration, it is Mr. Bakshi who facilitates the registration process. So I now request Mr. P.K. Bakshi to kindly deliver his address.
Good afternoon, everyone. Good afternoon, all dignitaries. Thank you, Pranam. So like most of the areas being already covered by our earlier dignitaries, here I want to give some little add-on. Like in most of the IP rights here in India during last 10 years of my practice, I have seen that most of the registered owners are pretty reluctant, including government and all, as Dr. Rajnikant already said, that enforcing the IP rights are very much in a lower importance in and within the participants, in and within the registered owner of the IP rights. Here I would like to put some focus upon the enforcement and the legal prosecution of IP rights, as like starting with the trademark. Under Section 103 of the Trademark Act 1999, penalty for applying false trademark and trade description. If somebody is infringing any false, infringing any registered trademark and falsifying that trademark, there is a specific provision of punishment that is provided that the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment. This is important. Impose a sentence of imprisonment for a term of less than 6 months, for a term not less than of 6 months, or a fine of 50,000 rupees. Here, there is a provision of enhanced penalty also under Section 105 of the Trademark Act, provided that the court may, for adequate and special reason to be mentioned in the judgment, impose a sentence of imprisonment for a term of less than 1 year, or fine maybe for 1 lakh rupees. This is the provision in the Act, but during the other course of various other prosecution in the court relating to other IP infringements, I have seen that in most of the cases, plaintiffs want to secure their compensations and the loss incurred by them due to the presence of other counterfeit products in the market relating to the trademark or any other infringement of patent rights. So, and the court will be pleased. Court in most of the cases, court feel pleased to award them the compensations with a specific points that the amount of compensation, etc., the volume of compensation, etc., must have proper justification and with evidential approach by the plaintiff that why the defendant should pay that much volume of compensation to the registered owner of the IP rights. So this is very important that once the IP rights being secured by a specific registered owner, whether it is a trademark, a copyright, a patent, a design right, a GI rights, or any other rights under IP law, he must enforce his rights. Otherwise, the value of these intellectual property rights, the huge benefits being provided by the intellectual property rights, will somehow be not properly being affected in the market. And there should be some kind of picture to go should go to the market that the infringing of IP rights are not a very low profile kind of a civil suits and all, where huge compensations and any other prosecution shall be delayed and it would take time or something like that. It is not like that. In my experience, I have seen the courts used to take these commercial rights very seriously, and the court moves these cases with a expedited manner, and in every month dates being fixed for hearings and other procedural prosecution under Code of Civil Procedure and Code of Criminal Procedures also. So resulting the IP rights are being well claimed by the litigants in the plaintiff side in most of the cases. Here it is pertinent to mention that sometime if our dignitaries will get some time, our participant will get some time to look into section 115 of the Trademark Act, cognizance of certain offences and power of police officer of search and seizure. This is important, that powers of police officer for search and seizure. No court shall take the cognizance of an offence under section 107 or 108 so and so, provided that in relation to the clause section A, court shall take cognizance of an offence on the basis of a certificate issued by the registrar to the effect that a registered trademark has been represented as registered in respect of any goods or services in respect of which it is not in fact registered. No court inferior to the metropolitan magistrate or judicial magistrate of the first class shall try an offence under this act. This is important, that no court inferior to the metropolitan magistrate or judicial magistrate first class. In this case, judicial magistrate first class means not the chief judicial magistrate, it is the district court, district and session court, which we commonly know. It is the district court who always try these kind of commercial suits. And in most of the other cities and places of India, a separate commercial court being established, mostly in the Bombay High Court. I was for one of my plaintiff filed a case in the Bombay High Court, and there I have seen that there is a separate commercial court which take these cases on a very expedite manner, and monthly there are minimum 2 hearings being fixed, and accordingly that case has been disposed of within a period of around 8 months, and the plaintiff is being awarded with the specified prayer being given in the plaint. So this is very important to know that the claiming the rights, enforcing the IP rights are always being beneficial, and I would urge all our participants even to come forward if they are already having rights or want to register for. Do not get delayed, and before publishing, the most important part of it is before publishing your IP rights or commercialize your IP rights, please come forward to file the registration, because the registration prosecution for whether it is trademark, copyright or patent or any other, it takes little time due to various reasons. There may be hearings, etc. There may be other relating delays, documentation, etc. Because of which it takes a specific time, and to ensure the rights, if that particular time being given to that particular invention or innovation, then it is better that before coming into the commercial aspect of that particular IP right, you will get the of that particular invention, you will get the IP right in hand at the time of commercializing your invention in the market, or whether it is a product or in service sector. It is very much important that we first claim the IP rights. Here, I want to mention one more part of the Trademark Act's enforcement. Under Section 115 only, subsection 4 says that any police officer not below the rank of Deputy Superintendent of Police. This is important, that a police officer not below the rank of a DSP or equivalent may, if he is satisfied that any of the offences referred to in subsection 3 has been, is being, or likely to be committed. This is important, that which may be likely to be committed. If the police officer find it right that yes, there may be a possibility of infringement, he can go for a search and seize without warrant the goods, die, block, machine, plate, other instruments or things involved in committing the offences, wherever found, and all the articles so seized shall, as soon as practicable, be produced before a judicial magistrate of the first class or metropolitan magistrate, as the case may be. Now, it is important that a DSP is having all right to do any seizing of the products without any warrant. This is very important. In this way only, the IP rights gets more value in the market. Once these search and seizure, if at least one case being happened, then the other possible counterfeits in the market may be neutralized. So that is a very important part, provided that the police officer, before making any search and seizure, shall obtain an opinion of the registrar on fact involved in the offence relating to the trademark and shall abide by the opinion so obtained. Yes, obviously, the police officer must ensure that the registration certificate, etc., being provided by the complainant is authentic, it's genuine. So he will ensure that yes, the rights are correct and it can be enforced accordingly. So in this way, the enforcement part is very much important in case of IP rights. And I want to repeat again that before commercializing your invention or innovative ideas or whatever you want to go for any IP rights, before commercializing it, please file your registration. That is very much important. And after that only you can enjoy the actual benefit of your IP rights. So that is that's all from our side, and we are always waiting for your call at ICC, and I hope that we'll get far more aspiring inventors from Mizoram University, obviously, and any other part of the country also, so as to ensure more and more strengthening of the IPFC and more strengthening of the IP claimants. That's all from my side. Thank you all the dignitaries for patiently listening to me, and I hope that in due course of time we will get more applications as well. Do not hesitate to file any complaint to us so that we can successfully apply the enforcement of your IP rights. Thank you very much all. Pranam, thank you. Over to you.
Thank you, Mr. Bakshi. So thank you to all the speakers. Just that prior to going to our question answer session, I'd like to inform that our chairman, Mr. Mahesh Sohore, was supposed to join us. He just for him. So anyway, now we will go for the question answer.
So Majumdar, I'm sorry to interrupt. Your voice is, I guess, not too much audible. If it can be louder.
Am I audible now?
Yeah, you are absolutely audible now. Thank you.
Am I audible? I'm clear and clear. Is my voice clear?
Yeah, now it's crystal clear. Thank you.
Thank you, sir. So now we are going to go to the question answer session. We have already received few queries. I'll start with those queries which we have received. Please don't mind my pronouncing the names if it might be wrong. So I'll just still pronounce it. We have a query from Lalthanwala Chongtu, who has asked that what is expedite examination in patent? How is it different from normal examination? Is it allowed for individual applicants now? So among the panelists, who would be Sanjay Bhattacharya, sir, would you like to
Yes.
reply to this?
Actually, reply is very simple. It is for startup and those companies who have opted for India as a such preliminary examination authority. They are eligible for to opt for expedited examination. But for individual, it is they are as an individual. It is only eligible if there is a group of persons in the inventor's list, and one of the inventor is a female or lady inventor. Then it is on that basis that group of inventors or inventor, if she is a lady inventor, they are eligible for expedited examination procedure. And the difference between normal and expedited examination is that it when it is applied with proper fees, immediately it is out of turn, examination is carried out within 1 month. Processing on that particular file starts. Okay.
Thank you, sir. I hope our the person who asked the delegate who asked the query, he has got her answer. Then I have another query from Mr. Venkati Subramaniam Ganapati. How can we overcome the challenges of copying plagiarism and other IPR violations? Any judicial remedies are there? Mr. Bakshi, would you like to answer to this?
Sorry, which one being asked for?
The question is, how can we overcome the challenges of copying, plagiarism, and other IPR violations? Any judicial remedies are there?
My entire discussion was upon this only, that all the IP rights are enforceable, and there are various judicial remedies, including claiming compensations, as I said, and search and seizure, etc. Like you can go for a criminal case by filing the provision of Code of Criminal Procedure section 156, where a police officer has got a very specific right to go for a search and seizure of the products, and once the counterfeit products being introduced in the judicial court, the court will take the matters on a very, very serious note, and the court proceedings shall be expedited automatically, and the plaintiff shall be given the appropriate protections, including claiming of compensations, etc. And the accused in this case may be imprisoned up to a term of 3 years. Thank you.
Thank you, Mr. Bakshi. We have another query. This is from G. Lalrim Ruata. He's asking, when applying for a patent application, are the online applications given high priority than the offline or physical application? The question was raised as one patent application was filed in 2011 and the patent was successfully registered only in 2021. So, Sanjay Bhattacharya, sir, would you like to say something about it?
Actually, we are not having any kind of priority on the basis of online and physical filing. Actually, we are doing that examination on the basis of request number. And there are, we are having 4 groups, examination groups in our office in order to handle patent application of different technological fields. So we are having chemistry group, we are having biotechnology group, we are having mechanical among engineering, mechanical, and electrical. Electrical group is covering that electrical, electronics, computer science, physics, and biomedical related inventions. And mechanical is covering civil, mechanical, then textile technology, and other allied fields. So now we are having our own resource to just give the service to the stakeholders. Now, those who are expert in a particular field, they are handling applications of that field only. Now, suppose in a particular subject area, there is a huge filing. In that case, that application, as I already told, that as per the order of the request number, it is auto allotment done through our software. So queue will be more. But suppose in some fields, as on date, I can share that in the field of chemistry, we are having not much of application. So just a moment. So in the field of chemistry, we are not having much pendency, and today we are almost up to date, and we are doing a request of the year 2020 and also 2021. And I think he has told about a particular application which was filed in 2011. At that point of time, we are having very limited manpower. And now we are having 600 plus examiners and 250 controllers. So we are geared up to give the proper service and in a quick time to the inventor and applicant. Last year, even though during a pandemic situation, we have issued 73,000 first examination report. And prior to that, previous 2 years, we have issued more than 80,000 FES. And we are having not much of pendency in FES, and just it is we are doing 2020, 2021 cases right now. So, and there is no discrimination about online filing and offline filing. Strictly on the basis of request number generated, on the basis of filing of request, applications are allotted online through software. Okay.
Thank you, sir. Then we have another query from Charu Silla. Under freedom to operate, if the patent is not Indian, then can we practice it in India without legal complications?
Actually,
yes,
let me clear it. Now, all IP right is territorial right. Now, those applications which are patented in India, that is under protection, patent protection in India itself. So, in beyond that, all applications which may be patented in other countries, we can freely use. Until and unless it is protected in India, there is no restriction.
Fine, thank you, sir. We see a raised hand. PC Roaming Liana, would you like to ask something, please?
Yes.
Kindly, you can put your question.
Yeah, Uttam, can you unmute him? Is it possible?
Yes. What is the name? Please say again.
It's PC Roaming Liana. He's an attendee.
Okay. Okay. Now he's unmuted.
Kindly put your question. Hello. Uttam, is she unmuted?
Yes. Yes. Already, I have given the rights.
PC.
Liana? Yeah.
PC Roaming Liana, are you there? Your audio is there, but we cannot hear it clearly. We cannot hear it clearly. We are seeing that your audio is activated. Uttam, any issues?
I think some audio issue in her system. I think so. Because she's
Anybody else would
unmuted.
like to? Okay. Anybody else would like to put up any query? There is somebody called Vanlal Hirata. The question is, are there any tips for avoiding any potential infringement on existing IPs? Are there resources to browse? The speakers among the panelists, kindly, whoever would like to answer to this question.
Yeah, Pranam, this is PK Bakshi here again. There is no such kind of specific mechanism to find out whether there is any infringement or all. Actually, all IP right holders should have a complete vigilance of their IP rights being counterfeited anyhow in the market, and also they can hire IP law firms who keeps an eye in the market, the publishing journals, etc., of trademark and patent, to look into whether the same or similar kind of IP rights, IP applications being already filed by someone or not, and in that way the oppositions can be filed. Even this practice is also here with us in ICC, that we keep an eye in the market, we keep an eye in the various journals, etc., whether similar kind of IP rights are already there, and accordingly we propose to the registered IP holder that they can file opposition case against those IP rights, and accordingly things can move on, and that is also a part of the enforcing the rights. This opposition is also a part of the enforcing the rights, and apart from that, in general market, we are having a mechanism to look into the general market for any kind of possible infringements, etc. So that can also be carried out. Yes.
Thank you. We have got another query. This is for Debanjan Chakraborty, sir. There is a query from Laltan Jwala Swangtu. Our question is, how do we define a well-known trademark?
Hello. Hello. Can you hear me?
Hello, Deban. Yeah.
Yes.
The question is, how do we define well-known trademark? And another question from the same person is applying registered trademark to goods and services other than the class in which the mark is registered by third parties still constitute an infringement?
I'll come by one. The
Yes, sir.
definition of well-known. There is a specific committee in our city or in our office, and we have members for them who actually recognize your mark, whether it is well known or not. So for me, anything which I use is a well known to me on an individual basis. But is it known to you or XYZ or the public at large? That needs to be evaluated. That is the basic function of giving well-known mark. So our team, by the evaluate the reach which your mark has, there are various parameters in which your mark is adjudicated. Thereafter, we give the well-known certification. And the specific laws are enacted in the Trademark Act also. And say, what was the second question for now? Hello?
Yeah, the second one, I'll just tell you.
I cannot hear you. Can you speak louder?
Can you hear me now?
Yes.
Yeah, the other question is applying registered trademarks to goods and services other than the class in which the mark is registered by third parties still constitute an infringement?
See, if you are a registered trademark owner and you applied for suppose soap, and some other person actually selling some tires in the same name or a cycle in the same name. In order to constitute an infringement, you need to have similarity in nature of the goods or service. So you need similarity in the of the nature of the goods. The basic idea of infringement is that are you affecting the goodwill of the third party or not? It is a judicial process. You can submit your contentions, and the judicial process will take its own course. Hello. Any other thing?
Yeah. Okay, sir. Thank you. So if anybody else has any query, kindly raise your hand so that we can see it. And Uttam, if you see a raised hand, kindly unmute that same person. PC Rongming Liana, are you still there? Sir, we are not able to hear you. There is somebody called Dr. G. Bhupesh. He was also there. Anybody else? If anybody else has any queries, please. Uttam, the PC Rongmiala, he's trying to talk, but we are not able to. There is Dr. G. Bhupesh. He has raised his voice. He's raised his hand. Uttam, kindly unmute him.
Yes,
Yes, sir.
he
Yes,
is
sir.
unmuted.
Yeah, sir. Is it possible to obtain the international patent like US or Australian patents are from Nagaland? Hello, sir. Can you hear me, sir?
Yes. I have heard your question. Okay.
Yes.
Actually, there is no such provision. Now, I already told in a reply to another that it is territorial right. So, but there is another option is that there are basically two options. India is a member of PCT and also to convention countries list. Paris, India is also a member of Paris Convention. So these are the two routes by which one can, an Indian inventor or Indian company can go for other countries. And if it is through a convention route, then after filing in India within 12 months, he can file in all other member countries under Paris Convention. And similarly, within a year of filing in India, one can go and file application in PCT with through Indian taking proper permission from India, and after once it is filed before PCT, with that PCT international application, he can just enter in any member country as per his choice. So that is the two route by which an Indian applicant or Indian company or Indian inventor can file in different countries of the world. And then separately in those countries, these applications will be examined. And as per the law of the land of that particular country, the IP law, it will be governed, patent law, it will be governed, and patent will be granted, or it may be refused also. That is the thing.
Sir, how long it takes, sir, for granting?
It depends upon the load. Practically now, all patent offices are now about our country. I told you that we are doing the request of year 2020 or 2021. So now waiting period is very less. In fact, after once that one application, ordinary application is filed, it goes for 18 after 18 months it goes for publication. Now, if applicant is interested for early disposal of his patent application, then he can. There is one option, that is to go for early publication request. So, for paying additional fee, one can get his application if he is filing complete specification immediately published, immediately after filing his application. In that case, that 18 months period waiting period is not needed. And if request is filed at the time of filing, then immediately that application will be in the queue for examination. So one can expect that within 2-3 years, if it is in normal route, he may expect to get his patent. And after issuance of first examination report, 6 months time is there, and it is extendable further 3 months. But however, applicant, if he is ready, he is in a position to file immediate reply. Once he gets his examination report by mail, he can very next day he can file. Practically, it is possible. But however, in normal case, maybe 15 days to 1 month time he can take to submit his reply. Immediately it will, once his response is filed, immediately again it will be in amended module, and subsequently action will be taken as per the load of that particular examiner controller here.
So in case of international patents, sir?
No, that you have to, either you have to go by convention, Paris Convention route, or by you can go for that PCT route, and then you have to file there, then respective country to decide how long it will take or not. India cannot have any control on that process. You can file definitely through that PCT route. Okay.
Okay, sir.
Oh.
Thank you, sir. Thank you, sir. Thank you for your a wonderful explanation, sir, on that.
Thank you. Thank you.
Okay, thank you.
If anybody else has any queries, if you want to raise your hand, kindly raise your hand. Anybody has any queries on GI? Welcome to. Hello, anybody? There is a query. I'll just check it. I think right now we don't have so much of queries. We can call it a day. So prior to we concluding this, I'd like to offer my vote of thanks to each and every dignitary. The onset, I'll again just in the beginning I said I would really like to thank the Honorable Vice Chancellor of Mizoram University, Dr. Professor K. R.S. Sambasiva Rao sir, for allowing this my video, some issues are there. I'm not able to show my video. I'm sorry. So for allowing this workshop which has happened today, I am sure this is just an initiation. Things will go ahead after that. We have all forms of resources at the Indian Chamber of Commerce in Intellectual Property Facilitation Center, and I request all the delegates, all the dignitaries to kindly avail the facilities they hear. I would like to thank Padma Shri Dr. Rajnikant sir. You have among your busy schedule, you have still been able to give your time to us. So thanks a lot for that, sir. And we hope to associate with you further in the days to come, sir. I would also like to thank Mr. Sanjay Bhattacharya, Deputy Controller of Patents and Design, a patent office called Kolkata. So you have always given us your time. Thank you for that. And we will be doing such kind of campaigns and workshops in the future also. We would be very happy if you would be a part of that. I would like to offer my thanks to Mr. Debanjan Chakraborty, Senior Examiner of Trademarks, Head of Office and CPIO Trademarks Registry, Kolkata, for your valuable deliveries. So you have also been always there for us whenever we wanted you to be a part of our programs. So thank you so much. Then I would like to thank Ms. Pearl Sopti. Thank you so much for being here. You have represented CPAM today. That's very valuable for us. In the days to come, since Indian Chamber of Commerce Northeast Office, we have an Intellectual Property Facilitation Center, where we are activating, and we are working very hard towards strengthening the IPR regime. So we would really request your support in future for enabling our center. Thank you so much, madam. Finally, I'd like to thank Mr. P.K. Bakshi, designated IP attorney, for your inputs. So thank you all again. Thank you, Mizoram University. Thank you to all the delegates from Mizoram University for giving a patient hearing. So thank you so much, everybody. Thank you. We can conclude now. Thank you.